We're back on, and the next witness is Mr. Pereira. And his witness statement. Redacted would be Exhibit 55. Ms. Burton?
Yes, you care to be sworn or to affirm?
Affirmed, please.
Affirm. You just raise your right hand, please. Do you affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Sorry, Mr. Chair. Just before we begin, as the tribunal is aware, Mr. Kahar and I had provided what we consider to be an appropriate redacted version of Mr. Pereira's witness statement. It's been marked as Exhibit 55, I believe.
Yep.
We have not heard back specific comments from Mr. Streisfield with respect to our proposed redactions, although I understand that he has some issues with it generally. And if we're going to have to engage in the same kind of discussion that we had earlier this morning with Mr. Chan's redacted witness statement, and I'm in your hands on that. But if we do have that discussion, in my submission, it would be appropriate for the witness to recuse himself in order that we can have that discussion.
So, you got to respond for him?
Yes. I was going to suggest we operate under the same guidelines as we had with Mr. Chan.
Yeah, and my suggestion is in terms of this particular witness statement is that the witness not be excused because only he can explain why a number of the highlighted items proposed to be included in Mr. Pereira's redacted witness statements are inappropriate redactions and relate to general principles overall. And the reason why I'm asking that in order to resolve this issue, only the witness can explain to you which paragraphs he cannot redact. I can't do it. Only he can, because it's his testimony. And I don't think that there are a lot of areas. Quite frankly, I think this witness, other than a few little minor things, is really supporting the urban design components of the plan. So we can go through this exercise, but the answer I can only give you is only the witness can tell you better than I why his opinion is what it is and why the redactions in certain areas are inappropriate in some cases.
So you didn't have any discussion with him at all about redactions, is that correct?
Oh no, we did have discussions about redactions.
Okay, so do you understand generally his views on it? I mean,
I do understand generally his views on it. And what I'm saying is there's just so much, even stuff that supports the plan, they've asked to be redacted.
well, why don't we operate under the guidelines that we had for Mr. Chan? Proceed that way, and if we run into eruptions, we'll deal with them.
Perfect.
So you understand where I'm going?
Fine. No.
We're going to start the evidence now.
We excluded
Direct the
Mr.
questions.
Chan. We excluded Mr. Chan, that's what I was asking.
No, we're not going to deal with the issues. We're going to deal with his evidence. Proceed with the evidence on this redacted basis. And if we run into eruptions, we'll deal with them at the time.
Thank you, sir.
Let's get going.
First of all, I would ask that Chris Pereira be qualified as an expert to give expert opinion evidence in urban design.
You want to direct, I've never met the gentleman before, and I'm not sure my colleague has either.
Oh,
And this panel only asks these, we know the firms that people are involved with, although.
you don't know this? Okay, well,
No.
we'll go for this firm.
I mean, this individual. Okay,
Perfect. No, absolutely. Thank you. So,
and we need a high level.
yeah, and I'll give you the high. Do you want to swear him first? Oh, sorry.
Sure did.
So Chris, can we just look at your CV and walk us through, first of all, who you are, what knowledge you have of urban design, qualifications you have, high level, and to the extent that the tribunal does not recognize the name of the firm, could you elaborate on that as well?
Sure. Mr. Chair, I'm the principal of Bahar Planning and Design Limited, a consulting firm specializing in community planning and urban design. I'm a registered professional planner and urban designer with 15 years of experience in land use planning and urban design. I have been involved in a number of projects involving residential redevelopment, infill, and intensification. I am very familiar with Richmond Hill and provided urban design expertise for several projects along the Yonge Street corridor in Richmond Hill, as well as within key development areas. I have appeared before the LPAT OMB previously on numerous occasions and have been qualified as an expert witness, as a planner, and as an urban designer. My role in the present appeal is to provide urban design evidence respecting the North Elgin Center appeal of the Yonge-Bernard Secondary Plan and the Yonge-Bernard zoning bylaw. In terms of the firm originated over 20 years ago with Moise Bahar. He's the founder of the firm. He was the director of planning at North York and Etobicoke for many years. I'm sure somebody has come across him at some point. He also invented the OPPI Urban Design Working Group. So since Moise has gone to a certain point of his career, he has obviously stepped back. I have now taken over the firm moving forward. So I am now the principal. In terms of my CV, I can very quickly go through that. Coming out of school, okay, perfect.
If there are any questions of anything on any of its qualifications, or people familiar with the witness? Okay.
Thank you, sir. Can you just walk us through how you became involved in the North Elgin Center lands and reviewing and the secondary plan appeal? How did you become involved in that?
Sure. Mr. Chair, MBPD was retained in February of 2019 by NEC, the owner of the subject property, to provide urban design guidance in connection with the proposed new secondary plan and to establish a development concept and a block plan for the Northeast Quadrant. My involvement was to advise the project architect and team on matters related to site layout, open space, building footprints, height, and massing, and other design related matters based on the new City Council's change of direction as it relates to the secondary plan, as expressed in the April 2019 and May 2019 council resolutions. Those are on page 4 of the staff report dated May 13th, 2020. I have visited the site on several occasions to help in my understanding of its context and to assist the project team in developing the proper urban design solutions for this particular site. I am intimately familiar with the policy framework applicable to the subject lands. I'm continuously assessing development applications in Richmond Hill and elsewhere in the GTA against applicable policies and guidelines and determining compliance with those documents. I have reviewed the PPS, Provincial Policy Statement 2020, the Growth Plan 2019 for any high-level urban design direction. I've also reviewed the relevant urban design policies in the York Region Official Plan and the York Region Transit-Oriented Development Guidelines. Additionally, I have reviewed the relevant urban design policies in the City of Richmond Hill Official Plan, as well as the under appeal Yonge-Bernard Secondary Plan and Yonge-Bernard Zoning Bylaw and the proposed May 2020 versions of these documents. So I guess this brings us to the first.
So now we hit, sorry. So So now we hit paragraph 2.8 and we have some redactions there. And in my view, the redaction is inappropriate by virtue of the fact that it's inappropriate for the reasons set out in the paragraph, that he has to be able to test the policies to see if they're workable. And therefore, he's giving his evidence on that basis. If he can't give his evidence to determine if the policies in the zoning are even workable, then I don't know how any tribunal acting judicially could come to a conclusion that it is.
No, get off that stick. Yes, Mr. Kushner.
So, Mr. Chair, we've now arrived at a fork in the road, and in my submission, my friend is trying to relitigate the same issue that has already been litigated 7 times now. The bright line distinction that this tribunal has ordered is that any issues relating to the secondary plan and zoning bylaw generally, with some subject matter exceptions like the Greenway, are appropriate for phase 1. Anything relating to specific solutions proposed for a specific quadrant that deviate from the secondary plan, such as the NEC concept plan, and whether it's a preferred solution for the northeast quadrant to what the secondary plan would contemplate, whether it conforms in part or doesn't conform in part, is a phase 2 issue. We can't be selective and say we're prepared to hear evidence that's supportive, but not the evidence that's not supportive. We're being consistent in that regard. And anything relating to NEC's concept plan, whether it may be supportive of the secondary plan or whether it may be critical of the secondary plan and zoning bylaw, that's a matter for phase 2. And that's why we've drawn that bright line distinction starting in paragraph 2.8. We have no issue with anything that falls under the rubric of B as in Bob, because that falls within the purview of the phase 1 issues. But anything in A, which relates to the specific NEC concept plan and the appropriateness of that concept plan for the form of development contemplated on those lands, this tribunal has very clearly directed 7 times now that that's a phase 2 issue. And therefore, my friend can't use that concept plan through this witness to try to poke holes in the secondary plan more generally, because that has been directed to be a phase 2 matter.
May I respond?
Just briefly, but
Yeah, Yonge,
of the view that we are dealing with the phase 1, which is his useful opinion on the documents, but not on a comparison or workability with whatever the concept plan is as proposed for the site.
I agree with Mr. Kushner in this instance, just because of the phrase, the redevelopment of the site. It specifically refers to your site, and that is a phase 2.
so if I understand the evidence that's been tendered today, Yonge MCD tendered their concept plans. It's already in evidence. Dogliola has provided their concept plan. In fact, it was even pulled up as part of cross-examination of Mr. Chan this morning. So I don't understand how you can have other people refer to other concept plans and he can't even refer to his concept plan. And the reason why he's just referring to it. Because
You've got the ruling, so let's proceed his opinion based on the documents in the global context of the whole area and not site comparison. So direct some questions. We'll see whether we bump as we thought we would.
So at paragraph 2.8b, it is not redacted. So just walk us through.
Sure. So, Mr. Chair, one of the things we wanted to look at when we initially looked at the secondary plan was to provide input into the city's draft document at a level of detail not yet found in any city initiated study at the time of the writing of this witness statement pertaining to the secondary plan. So that was one of the key, urban design assessments that I had done in preparation for the hearing and in preparing my witness statement.
And why would you have needed to do that?
Mr. Chair, so I mean, it's really just good due diligence on an owner's behalf to look at a plan, even whether it's draft or proposed, to understand how that plan, what the implications are of that plan on his lands, and how that plan or the proposed policies would influence or impact the redevelopment potential of those lands. So as part of a proper due diligence process, we need to look at those policies to understand which direction they are going and how they could potentially apply to in our case this quadrant, but really as on the 4 quadrants as a whole.
So we're still into the white on number 3, I guess. So we can start with that and just proceed with your paragraph 3 until we hit the first yellow.
Sure. So
On the documents rather than going point by point through his witness statements. Like you did with Mr. Chan.
Ms. Pera, can you please give us a summary of your urban design opinion with respect to the proposed secondary plan policies and the proposed zoning provisions? Just a high-level summary.
So from an urban design standpoint, I am in agreement with the kind of the vision of the secondary plan, which is to, and the KDA policies, which establish a greater mix of uses throughout the development. I agree that the vision under the Yonge Bernard KDA will be transformed into a cohesive community through redevelopment that builds on the area's existing assets, promotes a shift away from the focus on automobile use towards the creation of transit, cycling, and pedestrian-oriented destination, as well as a mixed-use urban center. So I do agree that the vision indicates that the highest and most dense buildings are directed towards Yonge Street, and the heights and densities will transition down from Yonge Street to respect the adjacent lower-rise neighborhood. These principles include appropriate policies to achieve urban plazas, to accompany redevelopment and enhance streetscapes, building height transition, low-density residential neighborhoods, and vibrant streetscapes. So in terms of a big picture vision and direction of the or from an urban design perspective of the secondary plan, I am in agreement with what staff have prepared.
What are the areas that you don't agree with?
I agree with most of what Mr. Theodore had submitted evidence on back in July. There were really only 2 areas that I have a difference of opinion with him on. That is the kind of merit of public street versus private street, as well as the merits of the front yard setback, which is whether it should be a minimum or a maximum. Those are really the only 2 areas that I have a difference of opinion than what Mr. Theodore had laid out.
May we proceed? Can you discuss the first area of disagreement?
Yes. So in his evidence at the time, Mr. Theodore had stated that he had relied on Mr. Terziewski's evidence that clearly outlined the technical reasons for the public road. Additionally, he noted that public roads were needed to create a pattern of smaller walkable blocks and that a public road allowed for greater control of access. From an urban design perspective, I want to note the following. So each quadrant has its own specific opportunities and constraints, and as such, secondary plan should acknowledge this and allow for some flexibility of that. Unlike the northwest or the southwest quadrants, the northeast is already established development block created by 2 public roads, Yonge and Bernard, and a channel block along its northern boundary. Putting a public road through these lands would not create an additional development block. Such a road would create more of a barrier between the rest of the quadrant and the contemplated linear park adjacent to the
Excuse
existing
me.
channel block.
Excuse me, Mr. Pereira. I can't write as fast as you're speaking. Could you slow down a little bit? Thank you.
I can do that.
Mr. Chair, Madam Chair, I'm sorry, I have to object. We're now talking about the appropriateness of public roads in the northeast quadrant and whether they should remain or whether they should be eliminated. That's a phase 2 issue. That's my first objection. My second objection is that all of Mr. Theodore's evidence was clearly laid out in his witness statement. Mr. Pereira did not provide a reply witness statement. There is nothing you will find in this witness statement that addresses any of this evidence with respect to public streets or with respect to the front yard setback issue, except as it relates to NEC's concept plan, which is a phase 2 matter. In my respectful submission, for both of those reasons, it would not be appropriate for this tribunal to hear his evidence in relation to public streets. Firstly, because he's characterized, the way he's addressing it is a phase 2 issue. Secondly, from a procedural fairness standpoint, his evidence is being sprung upon us for the first time now, not in his witness statement and not in any reply witness statement, which was never provided to us.
Mr. Streisfeld, any comments? Maybe Mr. Kushner is correct.
I don't believe that Mr. Kushner is correct on that this is all being sprung on us. I just don't understand how he could say that it's sprung at us. I'm looking at page 8.
Sorry?
I'm looking at page 8 of Mr. Pierre's redacted witness statement, and I'm looking at the last paragraph. And how
In
could you say
relation
it
to the
was
site.
no, but
North Elgin's position.
no, what is being quoted there, as I understand, is if you go to if I could assist the tribunal, if you could go to Exhibit 33 for 1 second, and if you could go to tab 9. So go to Exhibit 33, tab 9, and then go to page 36 in that tab. As I understand it, he is commenting on the staff report of May 2020 that went to council. In fact, all of these comments that have been struck relate or tie to the staff report. So my respectful submission, I don't see how this is so-called improper in any way or form. You can't have one witness that gets to say everything is a public road and deny somebody else from saying that it shouldn't be a public road or anything should be a public road in general, specifically on our lands or anybody else's lands.
No, you can't do it specifically. You can do generally the issue of public and or private with public access, etc. Not quadrant specific.
That okay?
And Mr. Chair, the difficulty I have, though, is that the only evidence that this witness has tendered in relation to public versus private roads is what you see here on page 8. It's all been provided solely in the limited context of the NEC site.
And there was no
That's a phase 2 issue. He has not provided any evidence whatsoever, no disclosure to the city or any other interested party with respect to any opinion on the appropriateness of public streets more generally. His opinion was solely given and solely cast in the narrow context of the NEC concept plan. That's a phase 2 issue, and given the lack of disclosure, he ought not now be permitted to expand that evidence into a more broader general opinion dealing with the KDA more generally, because that's not procedurally fair. My friend is familiar with that term.
Can we go to the demonstration plan then?
Well, we do acknowledge the fact that there has been no witness statement that deals with even the general aspects of the documentation. We did allow Mr. Chan some scope, and will allow the same sort of scope in general applicable to the whole, related and I guess fit it in with the unredacted parts of Exhibit 55. So, and you know, watch the bumps again. That's
I'll try as hard as I can, sir.
I'm sorry, sir. I didn't understand the ruling.
well, we're going to proceed as we did with Mr. Chan. He didn't provide a reply witness statement, and we did permit Mr. Chan some scope to give general opinion evidence. So we're going to do the same with Mr. Pereira. If
For example, on page 9, the current policy framework, he's addressed the regional and the city's official plan. I know that most of what you've done is redacted. Most of what he said is redacted, but in general, he could run through that. And then when he comes back, we'll have had his general opinions on the regions and the city's official plans, et cetera. Does that make any sense? I mean, I appreciate your argument, Mr. Kussner, but
I guess the difficulty, the challenge I'm facing, Madam Chair, is when I reviewed the witness statement, I did not see anything remotely critical about public streets generally. All of the evidence, the entirety of the evidence as it relates to public versus private streets was cast in the limited context of the NEC concept plan. On that basis, I did not prepare any cross-examination of this witness dealing with public streets versus private streets, because I wasn't given any fair notice that he intended to give any evidence whatsoever on the policy framework generally dealing with public roads versus private roads. I am therefore at the city is at a procedural disadvantage because I did not receive any fair notice, any fair disclosure through a reply witness statement or otherwise. And therefore I'm being frank here, I have not prepared any cross-examination of this witness on the issue of public streets generally. I'll be dealing with it certainly in the context of phase 2. I had no expectation or notice that I'd be in a position to have to deal with it in phase 1.
So what are you requesting then?
I'm requesting that this witness not be permitted to give any opinion evidence on the appropriateness of public streets within the secondary plan as a general matter.
Response?
My respectful submission, that's inappropriate. And the reason for that is first and foremost, is that when this witness statement was prepared, and as I understand it, I'm referencing paragraph 3.6, and perhaps the witness can just speak to it, that there was no demonstration plan available to even determine what the policies on the page actually mean or what they looked like. And if you recall, sir, the other day, I took Miss Anderson to section 5.4.5. I think it was subparagraph D or E of the Richmond Hill official plan. That section sets out the requirements for the preparation of a secondary plan, and what was required to be provided in any event was a concept plan, and none of that existed. So it would be impossible for anybody to determine if the policies were otherwise workable without trying to test them out and creating them on your own site. It's just impossible.
Why don't you just calm down and
No, I'm just sorry. I was just getting up to find the section.
well, just do it
Your
normally.
voice, your voice is
My
the
apologies.
objectionable
I'm
part.
just looking for the section. So it's 5. So it's section 5.1.5
Of,
D of the Richmond Hill official plan, part 1. And I think you recall I took Miss Anderson specifically to the section and I asked, what is the proposed development concept for the secondary plan area? And I asked her, does it have to be visual, or is it just in words, or what is it? Because there wasn't anything that it was ever provided to us to be able to determine if in fact the city had demonstrated compliance with the requirements set out in their own secondary plan. Hence, in the absence of anything other than words on a page, nobody would know what these policies mean or get translated to on the ground, in my view, but you have to hear the evidence, unless somebody tries to test them and put all of the pieces together. I think that this hearing has been, the concept plan that has been prepared is simply to test the policies. It's not that it's the concept plan, it's to test the policies to see if they in fact work. That's it. Nothing more than that.
Mr. Stracer, would you calm down and do it appropriately and
You
normally?
are shouting, sir. You are shouting.
Yes.
Sorry, should I turn it? My apologies. All we were ever saying is that there was nothing.
Why don't you use the microphone? We're just saying calm down and do it in a normal voice.
Maybe I got to turn my mic now. Sorry. That to us is the starting point, sir. There was, and you have to hear the evidence from the witness. Let him explain.
No.
How do you test these policies?
Would you? Good enough. That's about the 4th time you've said that. So, okay. Yep. Here we go again.
Yes, there is. No, he has one other thing.
You see, in a normal hearing, Mr. Streisfield, you wouldn't be hearing the panel discussing things, but you can pick up everything on these microphones. So just leave us in peace for a second.
Mr. Pereira, did you deal in your report 55 with the other issue you mentioned earlier, front yard setbacks?
No, I did not.
May I respond?
No.
The issue of the front yard.
No. He just said that it wasn't in the original document. So that's all the question I asked. I got an answer.
But it's in response to cross from Mr. Theodore.
Sir, you are not testifying. We just asked the witness what he said and what was in his report, not you.
Well, based on all of the comments made, we're both of the view that the evidence that this witness could provide to this tribunal will be phase 2 issue, and that's where he's appropriate. So we don't need to proceed any further with this particular witness.
May I ask him to respond to some questions that
No,
were elicited
no,
in evidence through Mr.
No.
Theodore?
Nope.
So he can't even respond to the questions that Mr. Theodore was put in?
Ruling.
Okay.
So the next witness, I gather, is
Mr. Augustine Coe, who's a land use
Oh.
planner at the region.
Oh, okay.
Unfortunately, he cannot attend this afternoon. He's going to be here tomorrow morning.
okay. Start with Mr. Coe tomorrow morning. 9:30. Thank you.
Because you're calling him.
Yes. Thank you very much.
Thank you.
That concludes the day. The earliest day we've had forever.
I'm sure. Thank you very much.